This is Sister Kristen, otherwise known as Misconduct. From Bartok Advanced Strategies, welcome to my channel, Truth Shoot, where we will discuss today how to post a bond to your court case. And in fact, I am happy to report that the Superior Court of California has accepted my bond. So I can speak from personal first-hand experience regarding this matter. And you should always post a bond, regardless of whether you are the plaintiff or the defendant. Here is the exact type of bond that I used. Now, believe it or not, it is a one-page document. Believe it or not, it can be that simple. You can call it a credit pre-authorization, or a bond, or both. There appearing no bond of record to initiate the matter regarding case number such and associated accounts, your proper name, spelled like a proper noun, undertake as follows. In consideration of the fact that no lawful money of account exists in circulation, and in consideration of the fact that I have suffered dishonor regarding the matter of case number such and associated accounts, I underwrite with my private exemption number, and there's where you put your social security number with no dashes. That's your exemption number. Any and all obligations of performance, loss, costs sustained by the Superior Court of California and the respectful citizens regarding said matter. And you sign as the authorized representative because you are the authorized representative for the all caps. This is a court form that I also used. This is an excellent court form for a bond, for a credit pre-authorization. You should check and see if you have one like this in your state. If so, fill it out. If you have any problems filling it out, you can contact me. Bartok Advanced Strategies, I'm not a lawyer. I offer legal strategies for research purposes only. There's a couple things that you need to know about the case bond. This bond is in the nature of a replevin bond. A replevin bond was formerly used in common law when there was a dispute and one party had a claim against another party. The moving party was required to bond the charge, the claim. The replevin bond was double the value of the subject property. Part of it was to indemnify the sheriff and or the court and or the defendant in case there is an unverified or unsubstantiated claim made against them. Now, you should know or understand that when you see your name in all capital letters, that's not you. That is a legal entity that is there to protect you. You are the living man or the living woman. And as a living man or living woman, the only law that you are under is the law of the land, which says that if you cause harm to a person or to their property, you're going to pay for it, period. That's it. That's it. Do not cause harm to anyone or their property, or you're going to pay for it. Now, is there an injured party? If there's an injured party, they need to bring forward a verified claim. You can't just bring whatever claims you want into court and hem people up behind it. So, but that's what they try to do to you. Now, in my court case, I'm the plaintiff. And it's nice to always try to be the plaintiff. But I understand that that's not how it always works out. If you are the defendant, you can use this bond that we're discussing here as well. People have used this bond and gotten out of jail. When they receive your bond, they have 3 days to do something with it. Some of those people went back to jail later because they didn't file their UCC-1 while they were out, which is a subject for my next video after this. So, understand that if you're a living man or woman, if there's no injured party, then there's no crime. The state can't sue you. The state can't interact with you because the state is a corporation, which is a dead fictional entity. And the dead cannot do business with the living. It doesn't work that way. It can't happen. Public and private have to remain separate, and you need to understand the difference. In equity, all charges need to be bonded. You've heard the saying, put your money where your mouth is? That's what they're talking about. This policy assures that the defendant will not be damaged by an unsupported claim. The charges are not usually bonded in modern court procedures. Well, they are bonded, but they wait until they have you in dishonor. Okay, after the court case has been decided, then they go ahead and bond it. There's two ways that the court can get to your trust account. First of all, please understand that judges are bankers. Okay? The judges have access to our accounts of commerce. When I say accounts of commerce, I mean our trust accounts tied to the birth certificate. It's just ticks in a book. It's just ticks in a book. Because when you were born, they realized, wow, this baby's going to need a lot of things. This baby's going to need doctor's appointments. He's going to need braces. He's going to need money for college. He's going to need a car loan, a house mortgage. Who's going to pay for all these things? He's going to need lights to have lights on and the PG&E. He's going to need electricity and a telephone. Who pays for all that? Well, did you think that the government paid for something? If you got money from the COVID situation, did you think the government gave you that money? No, they didn't. Everything you get comes out of your own trust account. Nobody pays for anyone else's anything. Every dime you get from the so-called government comes out of your own trust account, because only we the people have the power to create money with our signature. The man's credit is what gives life to the bond. You can voluntarily bond the case if there's no bond already on the clerk's file. Be sure to get a certified copy of the docket sheet as evidence that there is no bond in the case before you issue your bond. When you bond the case, you are the creditor, and the creditor always wins. If you bond the case and become the creditor, and then dishonor the judge, the attorneys, or the process in any way, you will lose your position as a creditor and go back to representing the defendant. If you bond the case and underwrite all the obligations, loss, costs of the honorable citizens of the state, that would include the attorney, as long as he is honorable. If he's not, and he refuses the indemnification, then I guess his commercial energy is going to be used for the bond, for the settlement. It's up to him. This is why lawyers have to bring their checkbook to court with them every time they come, because they're going to be on the hook for the money if they don't win that case. The judge will go along with whatever the prosecuting attorney requests. Usually, the attorney will tell the judge that the plaintiff moves for dismissal. Rules of the game. Rule number 1, the fiction and the real cannot mix. Public and private cannot mix. A creditor can issue a bond, which is evidence of a public debt, and use the bond to discharge other public debts. You are a private banker. There is no money on the public side, but debt is accepted as money. Now, when I was a kid and I got my first 25 cents or a dollar, whatever it was, I'm like 5 years old, and I'm excited. I'm stoked. I think this is cool. I got my first money. And along comes my older brother, 5 years older, and he tells me, oh, yeah, guess what? No, there's no real money. It's not backed by gold anymore, so there's no money. And I said, Grandma, Kelly says there's no money. And my grandma came out, and she pointed her finger at us, and she straightened us out. She said, that money is backed by the American people. And you know what? She was right. Your bond, you can issue a bill of exchange or use a bond. Either way, it is a bond, evidence of a public debt owed to you that discharges a public debt. See, in 1933, when they took all the gold from our grandparents, they had to give us something in return. Now, didn't they? Yes, they did. HJR, House Joint Resolution 192, states, go look it up, the government is responsible for our debts, dollar for dollar, to pay them for us because we cannot pay them anymore. There's no money, so we cannot pay for anything. That's our exemption. That's why we have an exemption from public debts. Now, if there was ever a time that the straw man was there to help you, it's right now when you have a court case or a situation like that, because the judge is a banker. He has access to the trust account, and that's what he's after. And he's going to get it one way or another. So let your straw man help you and protect you in this manner. If the state cannot file a claim against you because it's a fictitious entity and you are a living man or woman, then it must file a claim against a straw man to get to you. What is it trying to get? Does it want your body in jail? Does it want the money in your bank account? Your house? Your business? The answer is no. It wants your credit. The presentment is a complaint, a moving party. What is it trying to move? What is its complaint? It is usually using a statute as the grounds for the complaint. If public and private can't mix, the complaint must be against the straw man, not you. Why would the state care if a piece of paper violated a fictitious law? What is the motivation? The state is trying to move you to let it use your credit. If you refuse, the state can move the court to grant the use of your dishonor from your dishonor. So those are the two ways that the court can get to your exemption. One, with your authorization, your consent, or two, through your dishonor. Does the state really have a complaint, or is it just asking you for your help? Maybe the complaint is that it's out of money. There is no money, none on the private side and none on the public side, except for your credit. This system does use credit for money. What does the office manager do when it needs more money for paper clips? It requisitions the guys from the top floor for money to buy more paper clips. Now, do the bosses say, no way, of course not? That would be counterproductive to the purpose of the business. Think of the state as your business, since you are domiciled there. You need to be sure there are going to be enough paper clips, or the business may fall. Why would you refuse to honor the requisition? Why would you argue about whether or not the requisition was filled out properly? Why would you deny you're the one to fulfill it? Why would you ignore the requisition? Why would you get mad and start charging the messenger with fraud? LOL. If you ignore the requisition and spend all your boss's money trying not to fulfill the requisitions, the business will fail. And where would that leave you? Your business is down the tubes. You might be in jail for breach of contract. Your property has been taken by the corporate attorneys. Your money is gone. All the people who depended on your business have to use other sources. You're a very irresponsible businessman. If you had just signed the requisition, you would still be on the top floor. The state has no substance. It has no money. It has no inherent right to anything except what it has created, which it did create the straw man. It has a very important function. It has been charged with providing for the means by which you can go to the grocery stores, gas stations, libraries, shopping malls, sports car dealerships, and Walmarts. If it does not get money from somewhere, it cannot continue to provide the infrastructure that you find so convenient. The only source it has is taxes, license, permit, and registration, but this is not enough. They're going to need a lot of paper clips. The state needs to feed off your credit. And if you don't voluntarily let the state use it, the state will use your dishonor to take it. Now, have you ever had to ask your dad for financial help after you left the house and you were on your own? It's embarrassing. The state does not want to have to just ask you to use your credit. It's embarrassing for them. So they will have to find creative ways to ask you for it, to save face in the process. So the trick is for the state to ask you for your help without the unenlightened person, U.S. citizen, being able to see it. The state must have your credit, and it is going to get it one way or the other. That's what's going on in that courtroom. Nothing more. Do not argue the facts. The facts are on the moon. It doesn't matter. People have gone in there arguing the facts, great facts, for decades and gotten nowhere. Because they didn't understand what was really going on in that courtroom. It's going to get access to your credit the easy way or the hard way. It's all up to you. Honor. Stay in honor at all costs. Your mission, should you decide to accept it, is to honor the state when it asks you, in its aggressive way, to let it use your credit, your exemption. The state is raising you up as a creditor every time it gives you a presentment, like a parking ticket or a complaint or a grand jury indictment. You can honor the state by accepting its presentment and issuing an authorization voluntarily for it to get enough of your credits to settle the matter, dollar for dollar, or you can voluntarily dishonor the state by arguing and defending the straw man, which is what the system is set up for you to go into dishonor. Wow, this is a really hard choice. What should you do? There's an easy way and a hard way. The choice is always yours. The state is only following your lead. If you argue or defend, it gets to use your exemption. If you accept and authorize the state to use your exemption, then guess what? It is required to accept it. So when you use this bond and you act like the creditor and not like the debtor, the court is required to accept it. What do you have to lose? The state will get what it wants either way. Don't forget, there is no money. You need to go in there to settle the matter. You're there by special appearance. When they say your name, you let them know you are there in regards to that matter. You're there to settle the matter. You are the authorized representative of the straw man, of the defendant. You're not the defendant. You're not the straw man. You're the authorized representative. You're there to settle the matter. Now, there's 3 positions being played in that courtroom. And just remember that a court is a place to play a game. Tennis court, basketball court, etc. This is nothing different. The court is a place to play a game. There are 3 positions that will be played: executor, trustee, and beneficiary. Now, in reality, in the world, You are the executor and the beneficiary. The judge is the trustee. Okay? So until the executor shows up, the trustees are having a party. They're doing whatever they want. Okay? Everybody's got their dirty little fingers in everybody else's trust. Okay? But the moment the executor pops his head up and says, hey, I'm the executor, boom, guess what? The party's over. The executor gives instructions to the trustee, and the trustee fulfills those instructions. Period. That's it. You are the executor of your own estate, whether you filed the UCC-1 or not. Your name in all caps is a trust. It's a dead, fictional entity. It's a way that the state can do business with you through your all caps. The court presentment. The state just honored you with a court presentment. It is a verified complaint or grand jury indictment or traffic ticket. Do you feel honored? No. Why not? Are you angry? Are you confident you're going to be able to defend your position? That's not a good plan. Let's analyze this situation. What is this presentment? What are its components? It has your name on it? Stop. It does not have your name on it. It has the straw man's name on it. Now, all those statutes and codes, technically, those only apply to government employees, or they apply to you if you are operating in the capacity of the all caps. If you are operating for commerce, if you're a cab driver or a truck driver, then you're operating in that capacity. Otherwise, you let them know, I'm not operating in that capacity. And those statutes and codes don't apply to you if you are the living man or living woman. So it's really important they presume that you are the all caps, because guess what? You've got that driver's license that you carry around with you all the time, and you think that your name in all caps there, you think that's you, and that's a problem. You need to rebut the presumption that you are the defendant. You need to rebut the presumption that you are the all caps, and you need to let them know, because this is very important, brothers and sisters. Only the all caps can go to jail. Only the trustee can go to jail. If you're the executor, you can't go to jail. Period. Now, so you need to make it very clear, let the record show that I do not consent to be a surety to any court case. Now, when you fill out that court form for the surety, you're putting the all caps. Okay, the all caps could be the surety. He's the surety. He's the one. Not you, the living man or woman. Make sure that let the record show that you do not consent to being the surety. The moving party has named a straw man as violator of a statute and has asked you to take responsibility for the violation. The state, city, county, or IRS cannot file a claim against you, the living person. It's charging your straw man with a violation. Stop. It is establishing a value through an index associated with statute violations. This is ingenious. If you honor the presenter with an acceptance and return it, the index established the amount of credit you will provide to the state. It doesn't matter if you don't know what that amount is. They do. That's all that matters. If you dishonor, again, the index establishes the amount of property the state will take to get the credits it needs. The presumption is that you are in partnership with the straw man. In some cases, the index establishes how many months the state will hold your body for breach of fiduciary duty while it collects your credits, and they get $10,000 a day per inmate, floating bonds on those individuals. And believe me when I say that all those people who are in jail agreed to be the straw man at some point. When you get out of jail, they'll write your name back in the proper name again. Now, what does it matter how they spell your name? Well, maybe it doesn't matter to you, but it matters to me very much. And I've seen people personally with my own two eyes who told the judge, hey, That's not how I spell it. That's not how I spell my name. That's not me. And guess what? They got out of jail and the case was dismissed. And I swore to myself that I would study and learn and understand what was really going on in that courtroom, which I'm sharing some of that knowledge that I've gained with you today. So, if you are able to be strong enough and firm enough to stand on your square and just let them know, hey, that's not how I spell my name. Are you dumb? That's not how I spell it. First of all, it's very important that we are able to agree on the rules of grammar that we are going to use. Or how will we ever be able to enforce our contracts with anyone? Okay? You can ask the judge, does this court follow the rules of grammar in the government style manual, the United States government style manual? Which, yes, they do. They have to. You spell a proper name in the proper manner. Don't ever let them call you the all caps. And let them know, hey, that's not how I spell it. It's not me. That's a legal entity. Now, if you have filed your UCC 1, then you can let them know that the all caps is your debtor. So, of course, that's not you. Now, the complaint has the name of a party bringing the claim. Someone has approached you and asked for your help. That person is taking a big chance. By signing his name, he could end up owing the amount the state is asking from the defendant if the defendant beats the case. Options. You have options. Defend it, argue about it, conditionally accept it, ignore it, or accept it. And there's only one good choice, accept. If you defend, you are refusing to take responsibility for managing the affairs of your business, the United States. Whether you want to admit it or not, the United States is your creation. It continues in business because you authorized it. If you argue, you are in a controversy with your own business managers. If you conditionally accept, you are requiring the United States prove it has a claim when it is in receivership and cannot have a valid claim against you without your permission. If you ignore the presentment, you are acting like an irresponsible creditor and you will lose your status as creditor. The best choice is to accept it and return it, but that by itself is not enough. You have accepted the presentment and charges, but you have not given them what they want and what they need. Your credit, your exemption. When you accept the presentment for value, you have to follow through with some type of instrument. If you do not authorize the state to use your credit to settle the account after you have accepted it, you are in dishonor. If you do not authorize the attorney, the prosecuting attorney, to use your credit to settle the court amount, the court account after you have accepted it, you are in dishonor. So after you posted your bond, you need to let the prosecuting attorney know they could go ahead and write the check because your bond is going to cover it. And you need to do that. The state and the attorney will then use your dishonors to charge their agents with authority to take you to jail. Either way, the state and the court will get the use of your credit. The United States and its states are in receivership. So they do not have any credit of their own. They need your credit and they will get it. The corporate counties and cities are in this dysfunctional situation. They all need your credit. When they ask for it, give it to them. The presentment is like a check. It is sent to you with a request for some kind of payment. If you endorse it and return it, they know you have approved the use of your credit. Boom. You see how that works? It's very simple. They can then use your endorsement to settle the debt. Instruct the judge, I'm authorizing you to act as my trustee to settle the matter. There is no controversy. There's nothing to dispute. I'm here to settle the matter. That's the type of language they can understand and respect. They just need your authorizing signature to get the credit to enter on the books. Remember, there is no money. I hate to tell you this, but if you sign your name on a piece of toilet paper and leave it behind in the bar and a banker comes in and gets a hold of it, he will securitize it. Okay? Your signature creates the value. Now, if anyone is interested in a telephone consultation, limited time offer only, they can contact me. And it's only $25 to PayPal. The information is here. Just remember, if you want judgment, bring it. You have to know how to enforce everything in this life. Take care, and I'll see you in the next video.